known around for inventing something. Yeah, have you admitted, ma'am? Yeah, thank you. Now, like you make an invention, that invention is yours, and that gives you some exclusive rights to use it. Now, that is whatever I have invented, whatever I have made an invention, that invention gives me a kind of right which nobody else can claim. That's basically a right which I have about the invention. Now, patentability. Now, to make an invention to be patentable, what is required? Significantly, it should be like industrially applicable, that is useful. The invention which I'm inventing is should be useful. And the second aspect is it should be novel. Novel means new, that nobody else, no one else other than you has invented this. Then you have the one who have invented this, none other than you have the credit of inventing this. Then inventive step, that is uh, I invent something which is non-obvious, which is not obviously found by everybody, which is non-obvious. But then few things which are non-obvious and which are new, but they are yet will not be approved as a patent thing. Now, suppose example, discoveries of materials or substances already existing in nature. For example, if I discover a new kind of metal below the earth, now it is what it was actually there in the nature. Now, can I get that metal? Like suppose a metal which is not a copper, a metal which is not a what do you say, a gold or a silver, something a different kind of material which is relatively new, relatively new, and which has nobody has found it, but still it was beneath the earth. Now, this is not my invention. I have not invented anything. It was already there, but I've taken it out. That's it. But which was already existing in the nature, I discovered it. That's it. For that, I won't be getting any kind of patent. The next is scientific theories or mathematical methods. Now, Pythagoras theorem, x plus uh, a plus b the whole square. Now, this formula. Suppose somebody formulates in a very different manner. Of late, somebody like you might have seen people formulate this in a very different manner, where it is actually not, like they pronounce it wrong or they get it wrong, whatever it is, or they, what do you say, manipulate it. Now, any kind of manipulation to a scientific theory or a mathematical method which is already there, you will not be getting any kind of patent to that. Then plant or animal variety, that is a biological process. If I find a fish beneath the sea, a transparent fish, a fish which is very transparent, which is very silky, soft, but then nobody has seen that fish. But I was the one who saw the fish first. Can I ask for patent? No, because it's a biological process. Animals are born, like animals, trees are born by a biological process. There is a process where the earth produces plants, and the breeding of animal produces another animal. So there's a very biological process. For this, I personally don't do anything. So I'll not be getting any kind of patent to it because it's only a biological produce. Then there are few games, mental games, like suppose cross puzzle is there, crossword is there, then word count is there, then like you have seen images, you have to make shuffle, like things are shuffled, you have to make it into an image, you make it. These all are play, like playing acts, playing games. There are various methods or like business tactics. These cannot be made as patent. Now, methods of treatment. See, one disparity people might have. Now, suppose some doctor may have given crocin to you if you are feverish. 1 minute. 1 minute. I'm admitting a student. Yeah. Methods of treatment. Now, some doctor might have given you crocin. Now, that crocin would have would not have cured your fever. Now, somebody might have given Dolo 650. That Dolo 650 might have cured your fever. Now, that is a method of treatment which a doctor follows. Now, medicines can be patented, no doubt, but the method of treatment to humans or animals, any diagnostic methods practiced will not be considered as patent because these are only methods of treatment. Now, that is not an invention by you. See, it happens, you get a heavy, like you are coughing. So, doctor will give you one medicine that has not cured you. Then he'll go to some other medicine. Then, even that didn't cure you. Then he'll go to some other medicine. Now, these are methods of treatment adopted by a doctor. Now, that cannot be given, that cannot be allowed as a patent. Hope I'm clear. Now, next is industrial applicability. Any manufacturing process, any product you make. Now, see, you cannot make a waste product. You can only make a product which is practically usable, utility, which has a utility in it. Suppose for example, I make a rubber. Now that rubber has a utility, right? Um, like I can rub whatever I've written with a pencil. Now that rubber has a utility. Same way, anything you make should have an industrial process to it, plus should be used, should be utilized by you. Now, next is novelty. Novelty, like anything which is fundamentally new, or one which cannot be easily done. Suppose example, um, if I bake a cake in 15 minutes, it bakes, right? Now everybody knows. Now, if you put the cake in the batter, it will take almost 15 to 20 minutes. It will bake. Now, there's not now something new. Everybody can do it. So that is not new. A thing which is new, which cannot be proved. Nobody else can do it other than you. Like, so for example, you might have come across, no, during summer seasons, we take a lens and we take it in front of a paper. That paper burns because of the sun rays, radiation. Now, this is not a magic. Everybody can do it. Now, can I go and claim such as a magic, like something I'm new have invented? There's nothing new. This is a used technique which you are using it. And like if I am doing it, any small child can also do it. Can I say that's novel? That's not novel. An invention which will be not anticipated. Nobody might have thought about that invention. For example, a guy made a very small material, so small. Nobody could have ever imagined that he could have made such a small satellite. So he made a very small satellite. It was a very new invention. Nobody would have predicted in their weirdest of image that he could have made a satellite as small as that. Now, in such a case, he may get patent for it because nobody before him has invented such a small amount of satellite. Then, if that thing is in a general parlance, that is, everybody knows about this thing, nobody can claim the patent. Now, disclosure of the patent. That is, you have to disclose your patent. Why? Now, why you are supposed to disclose the patent? Because if you have invented, you should have known everything. If I have discovered anything now, that will now, I'm the one who can explain it the best. I am the one who can make it again. So it is for me to disclose how did I make this product. That is, he can actually disclose how it was made. Now, how he made it actually. Now, now disclosure of invention. Disclosure of invention means what? The requirement of patentability. Unless you disclose, you will not get patent. See, there'll be a patent officer. To him, you should disclose everything. How does it processes? How does it work? What is the product? What is the use of the product? How did I create it? How long did it take to make this product? Everything has to be disclosed. Can I say I have invented and I'll not disclose you? See, for general public, I need not to be disclosing it. That's fine. But for others, that is for general public, I need not be disclosing it. But for the patent agent or the patent officer, I need to disclose it. Just that he understands that it's my invention. 9. Then drafting and filing of patent application. Now, draft, this is a very important step where I identify my invention, where I find out my invention. Now, I'll tell the other party, that is the officer of patent. I'll tell him what are the features in my invention, combination to solve a technical problem, how, or like how technical it is, how will I solve it, then how does it fulfill the legal requirement of being a patent. I have to tell him all. How I like what are the features of this product which I am seeking to. What is the efficiency of this product and what is the benefit of this product? I should tell them all. Then next is practical aspects of drafting patent application. Now there are steps. I'll come step by step. Now then like the application should relate to one invention only. When I'm going for description, I should make one application for one invention. Then, second is if I am talking about the invention, I should completely describe about the invention so that the other party sufficiently understands how did I make this product. Then, third, now he should clearly and concisely tell the description of the product. That is, he should broadly classify under what kind of product does his invention come. What is the best thing his invention can do? What he claims. Suppose I invent let's say for example any mop, okay, or any vacuum cleaner which cleans the floor within seconds. But then by cleaning it, it does not allow unnecessary dust inside. Now, this is my invention. Now, if it is my invention, I should explain them how this vacuum cleaner works. Now, drafting patent application. Now, when you are discussing with patent agent is an attorney who will file your invention. Now, what all you should provide? complete details of invention as well as failures on the way of invention. You should tell me how. You should tell the patent agent that how did you uh, make this product and how many times you have failed. That is now it is not possible, right? And on my first attempt, I make a product. I'll fail one times. I'll fail 10 times. I'll fail 20 times. I'll fail 30 times. I'll fail 100 times. That's okay. Now I should tell him how many times I have failed in making this invention, and then what was the end result? When did I find it? Now, if the patent agents ask you that where did you get the idea from, or did you copy the idea somewhere, keeping other inventors' work, or an inventorship, or did you take it from anybody else, you should not get offended. It is his duty to ask, right? He'll ask, where did you get this idea from, or did you copy from somewhere, or did you take it from somewhere? He'll ask such kind of questions. You should be calm, like you should answer him. If it is your what is it, it's your, if it is your invention, you are definitely sure you can answer any kind of question. Then you have to explain how far this invention is novel, inventive, utility. Like you should tell them my invention is so useful. Now if I'm telling it useful, how is it useful? He'll question you, how is it useful? You should tell him in what way your invention is useful. Then whatever documents I have in possession, maybe I'm designing a what do you say, a machine, a carburetor, a engine which consumes very less petrol. That is for 1000 kilometer. If you put 5 liters of petrol, you can go for 600 kilometers. This is the engine. Now I have a design of engine. That engine sucks very less petrol, and that consumes very less petrol and very less oil, and keeps the engine always lubricated. Now this is the thing. Now if it is there, now for that I need to make a design. How does that engine work? If I have made a design, I have to show it to the patent agent. See, this is the design. This is how the engine of the bike consumes very less petrol. And suppose if your invention is development of any other invention, you should frankly tell it to the patent agent. That is, this was the particular person's invention. I had developed that invention. Then, then a detailed way of explanation. For example, if I am, how can such a product be useful? Suppose I invent a camera which can take pictures from 2 kilometers, like from at 2 kilometers radius or at 1 kilometers radius, I can take pictures. Now I should tell him, see, I have invented this camera which can take the pictures of people 2 kilometers away from. Now I should show him how is it useful, why I have developed such a camera. Then you should show your trials. Like might be you might have taken pictures 2 kilometers away. Now you should show him pictures. See, this picture I took it 2 kilometers away. See how clear it is. See the clarity. See the resolution of this picture. See the see the image. See the clarity of the image. Like how far I have made this camera. Then, whenever the patent agent asks you questions, you should respond it quickly. Why quickly? Now, you should not Google it. Like if he's asking you some questions, then what? That is, you should immediately answer it because it's your invention. If you have not invented, you could have Googled it, right? Am I clear? Hope I'm clear. Next is like processing of patent application. Now I go to processing of patent application. Examination. Now, what is examination? They will check whether the invention which you are claiming to be new, whether somebody has made such an invention before your date. Then, if no application is filed before your application, then it is to be understood that you are the first person who are claiming for this patent. Now, right to priority. That is, one who files first will get the patent. That is understand it, and that was developed in Paris Convention. Under Paris Convention only, everybody gave importance to the priority. That is, one who seeks first will get the protection. Protection. Then next is examination of substance. Now they'll examine what kind of examination is. They'll if the invention is excluded from patent protection by the provisions or legislation, then the inventive step which you are asking, which they are asking for, which is not there, then the invention is not clearly disclosed. If you have not if you have not disclosed the invention completely, they'll reject. Otherwise, if your invention does not involve any inventive step, any new step, which is the only old step and which we have repeated, then you will not get patent for it. Then next is publication notice and opposition. See, I'll tell you. Now, suppose I'm going for invention, going for some invention where I invent a pistol or I invent a lie detector. Okay. Now, that lie detector is not injurious to your health. Like, it's a small pin kind of a thing which I put to somebody's body. If I put to somebody's body, I'll come to know whether they are speaking truth or lie. So which is not injurious to the public, and which will be which will be accepted by everyone. Now if I give it, now that will be published in the newspaper and in the patent office. That is, they'll file a, what do you say, notice to everybody, to anybody, like Mr. Abdul is presenting such a invention. He says it's a new invention. If anybody who has made such similar invention can raise objections. Now, if anybody raises objection, then what? The patent, somebody has raised objection or opposition to it, then he'll give them an opportunity on what basis they are objecting, whether it is not new or whether it is not inventive step, or industrial application is not there, or insufficient disclosure is there. Now whatever it is, they'll come and tell. And then if they are if the person applicant, that is patentee, if the applicant satisfies their patent officer, that's okay. If he does not satisfy the patent officer, his application will be rejected. Next is grant and publication. When in the examination process, okay, uh, like there was an objection and the conclusion came in favor of the applicant, like he has fulfilled all the requirements and there's no opposition filed by anybody, and whether they have filed an opposition which was unsuccessful, which was not successful, then the patent officer will grant the application, that is, will grant patent. Now then, once you are granted patent, what they'll do, they'll enter it into the patent register. What they'll enter, bibliographic data such as patent number, name and address of the applicant, patentee's name of the inventor, original application number, filing date, certain priority application details, title of invention. Now, these are very general information. Who invented this invention? what is the patent number given to him, what is his current address or what is his permanent address, then what is the name of the inventor, what is the original application number, what was the filing date, what is the title of invention, what this it will contain, but it will not contain any technical information. You're getting it? These are very basic informations which will be entered into patent record, patent register. Now that register will have following details of the inventee. Then you have to pay annual fees to patent office so that they maintain the record. Then why such a register? The question comes. Now, if I want to make an invention, I can go to patent office and I can see whether such an invention has been bought before. So, a provisional inventor, that that is a person who is going to invent something. It is very helpful for him. Before his invention, he can take a look at it. Then patent, now next is, first is it will enter the name in the register. Second is it will publish in the official gadget. Now official gadget may what will have official gadget, what kind of invention it is, then what is the bibliographic data, then what is the abstract of the abstract and main claim, the drawings, for example, whatever, if a machine is there, I have drawn the working of the machine, that working will be shown in the official gadget. Then next is certificate will be given. Now what is certificate? That is, you are the patent patentee for this particular invention. That certificate will be given to you. Then the patent office will make documents in printed form, whatever documents the man submitted. They'll make as a printed document and keep it at the patents office by patent, like as a patent library. That is, whatever invention is there, no, they'll keep it as a book. Every single invention will have a book. Now that will be in the patent library. Every invention is in a form of book. Everybody can take a look at it. How is it made? How does it work? If at all anybody who is trying to invent something, they can have a look at that register. Next is, see, I'll tell you the basic steps so that you don't forget. First is you will go and make an application for patent. Then there'll be examination of the form. Then they'll search that whether there is any such kind of invention has been claimed before or not. Then there'll be examination of the product, how the product is made. Then if they'll ask for objections, if anybody has objections, they can file objections. Then if objections are filed, then they'll call them, they'll ask them what is the problem. If the objection has been unsuccessful, then they'll grant patent. Then the grant of patent will be published in the official gadget. Hope I've cleared this topic. I'll move on to the second topic.
So I would like to ask,
Yeah.
hello.
Yes. Go ahead, boy.
So like a renewal, the fees, like what is that like term? After 20 years, we have to go for a renewal. Or what?
Yeah. After 20 years.
So then, like I don't want any renewal. Then what is the process of IP?
Then the invention will be taken at common domain. Everybody can use it. It is not your invention.
So like if I want to claim means then I have to pay.
You have to pay every 20 years.
Suppose I would like to ask, sir, suppose 1 year, like Renewal I have not done. After 5 years, can I go for renewal? After the,
Yeah,
like a 20th completed, I don't want to renew in 21st. I'll go for a renewal on 25th year. Is it possible?
uh, it is possible if you communicate with the patent office. If patent office has given it to government, then you cannot claim it back. At least you notice that if you're not coming and renewing the utility or the invention, it will be given to government. Now within that time, if you go and renew it, that's fine. Then if you don't renew it, it will go to the government.
I don't know that thing. I don't know. I maybe intentionally I ignored, but all of a sudden some boom come and I have to go for a renewal. I have to claim my royalty or something.
You
Ownership.
can, you can if the patent office has not given it to the government.
Okay, okay. Sir, and what is the like to get a process? What is the time period, sir?
No,
To like application to like grant of a file number.
see, it is like it is a long process. The like the process you have to explain. Then there'll be advertisement of that process. Then they'll put an advertisement. At least year or two you'll take, but there's a huge process. You make an application. That application has to be accepted. Then on that application they'll make examination. Then on that examination they'll call you for demo. Then you have to demo that in front of them. Then after that demo, if there's any objection, you have to clarify those objections. If there are any doubts, you have to clarify those doubts. Then if no objections are there, only then you will get patent. That's a very long process.
Sir, some of the files like a seized patent. What it means, a seized application? Like after
See,
not pay, no.
seized means the government will take. See,
Government
there
will.
are two patents where the government will not give it to you. Suppose
Okay.
if I invent a gun which
Yes, sir.
suits a people, now that will not be given to me. As soon as the patent office comes to know, no, they'll seize my patent and they'll not give me the right to proceed with it.
Thank you, sir.
Like, yeah, okay. Next is, I'll go to,
Sir, okay. Sir,
yes.
sir, what is the difference between the disclosure and description, sir?
Disclosure is you will tell how did you made it, how have you made the invention, how many times you have failed, how many times you have attempted, what are the positives, what are the negatives. These are disclosure. Description is like point by point what is required to make it. Suppose I'm making a soda. So, what is to be added? You have to add sugar, you have to add gas, you have to add lime. This is description. The
Okay,
entire how many times you have to wait, how long you have to understand. This is making description.
sir.
Disclosure is, yeah.
Okay, sir. Tell me, sir. Tell me. Explain me, sir.
Disclosure is telling how your invention is.
Okay,
Description is how to make it.
okay, sir. Sir, in while I'm referring something, it was mentioning prayer art. Prayer art means what, sir?
Prior art.
Yes, sir.
Prior art means you have to submit him specification, provisional specification. Means what? What is your invention? You have to tell him very shortly. That is what I call as prior art.
Thank you, sir.
I'll go on to the next topic.
Prior, that is like prior means something like we are going for the Google citation prior to know that to duplicacy free. It may be.
Now, patent rights and infringement. Now, exclusive right of a patent owner. Now, what are the rights does a inventor have? Now, see, he claims a definite monopoly over the subject. Now, he is the one who invented. Only he can use it. Okay. Then, if somebody takes his invention, makes improvement, makes development in his invention, then the other party has to pay royalty. For example, suppose you have invented something. I took your invention. I have improved, I have developed the invention, then I should be paid royalty. You should be paid royalty. That is, I am supposed to pay royalty to the person who has invented it. Next is, now, like, patent owner can use it by on his own, or he can transfer his patent to somebody else. That's okay. Now, then, finally, if your invention is of public utility, that is for what I can say, for public interest. If your invention is for public interest, then government will take your invention. Only they can multiply your invention. Next is the enforcement of right. Now, one who infringes your right, okay, now you can take an action against you. You can file a suit against you. Nobody can use your invention other than you. That is, if somebody uses my invention without my permission, I can file a suit on them, and they have to pay compensation to me. Then, if at all the infringer asks for your product, you can sell it. You can sell your license if you want to, but then for money. But when I'm talking about infringement, what I should prove, that is the other party who is using my product is a prohibited act. That is, I only invented that product, and nobody else should have a right to use it. Then I have to prove that I've already published regarding this invention, and this man is using it unauthorizedly. Then the prohibited act, which I'm asking, which we are talking about, is like you're using it, or you're selling it, or you're importing a patent product, or the use of patented process, or making, selling, importing product directly obtained through patented process. What are you doing? You're selling somebody else's product. You're using somebody else's patent. You're importing somebody else's patented material without their permission, and you can't do it. Then, next is remedies against infringement. Remedies against infringement. Now, say there are civil remedies available to you. Remedies are nothing but what are the like, what are the options you have. If somebody uses your patent, what is the best option you can have? You will have civil actions, the remedies available to a patent owner. If you establish that there has been violation of your infringement, there are civil actions also, and there are criminal actions also. Now, what are civil? Under civil, you will get damages. Now, what are damages? Damages is compensation. If it is your invention and I have used it without your permission, then what will happen? I can, I can file a suit on you that you have used my invention without my permission. You have to pay compensation. This is civil. Then next is grant of an injunction. Injunction is nothing but a stay order kind of a thing. Now, stay order means what? Where the court will ask you, the infringing party, not to use the invention further. They'll stop you from using the invention. Then, uh, suppose you have multiple copies of my invention, then the court will order to seize your invention and destroy the material. For example, like I said, I've invented a vacuum cleaner. You also made a copy of it. Now, if the government, the court finds out that you have infringed my invention, you have multiple copies of it. What they'll do is they'll take all the copies which you have and they'll destroy it. Damages is money given to you. First is like injunction. Like, there are three things basically. One is damages, that is compensation to you. Second is injunction, that is stay order to you. Third is destroy of the material which is there. Then exploitation of patented invention. Now exploitation means what? When I have made this product, so I can sell it, I can transfer it, I can license it to somebody for money. That is, the economic well-being of me is very important. Then compulsory license. Now now compulsory license is non-voluntary license. That is your invention which is benefit for the public. For example, I made a medicine for COVID-19. Okay. Now, for that, the government will take my invention and they'll pay me some money. That is what I call as compulsory licensing. Now, that is in two cases, you will be given compulsory licensing. Now, suppose I made a product, okay, I made an asset form, but and that asset is patented. By using that asset, I can clean a rusted iron within 2 seconds, and I can convert a rusted iron into new iron or a new material. That asset I've invented. Now, while that asset I've invented, I'm throwing it on people. Like I'm like those who are fighting with me. No, what I do is I throw on them. This is the abuse of patent. I'm not using the patent for a good cause. I'm using it for a bad cause. In such a case, they'll grant me compulsory license and they'll take the material from me. Then, if I make any material that is public welfare, health, defense, development of country, if I make a missile, Mr. Abdul Kalam made nuclear weapon. Now, though he made nuclear weapon, he will not be granted patent. Why? Because it is for the defense purpose. The government will take it for themselves. When further I go to non-working patent. Non-working patent means a patent which is somebody has invented, but that is not that useful or that is not benefited to the public. That patent will not be granted. Then next I go to, give me a minute, page 002. One second. Next, I go to Paris Convention. Now, Paris Convention is the most important document when you talk about patent. Now, Paris Convention for the protection of industrial property. There was a conference held in Paris in the year 1883 for the purpose where there was a convention by by 11 states, 11 countries, uh, such as Belgium, Brazil, El Salvador, France, Guatemala, Italy, Netherlands, Portugal, Serbia, Spain, and Switzerland. It came into effect on 7th of July 1884. Now, these are the countries who actually signed for this con- convention. Now, see, there are Paris Convention was revised from time to time. After 1883, it was again revised, and it was again produced in the year 1900 in Brussels conference. Then it ended its adoption again in the great majority of country are now party to Stockholm Conference, 1967. Now, most of the countries are now party to Stockholm Declaration. Now, see, I'll tell you the main conventions for the intellectual property rights. Uh, like new conventions are PCT, that is Patent Cooperation Treaty, then Budapest Treaty for Disposition of Microorganisms, then Union for Protection of New Plant Varieties UPOV, then Madrid Agreement for Representation of False or Deceptive Indications of Source of Goods, then Madrid Protocol concerning registration of marks, Hague Agreement concerning deposit of industrial designs. Now, all this somehow or the other talk about the intellectual property rights. Now the main what are the main features of Paris Convention? First is national treatment. Now, what is national treatment? That is, if anybody makes an invention, like not only foreigners will be protected, but they will not be discriminated. If I make an invention and a foreigner also make an invention, like I'm an Indian, I made an invention, and then my neighbor is a Japanese, he also made an invention, but now his invention and my invention will be treated equally. Both will be given national treatment. Both will be treated equally. There should not be discrimination between him and me. Like under this national treatment rule, the foreigners will not only be protected, but they also will not be discriminated. But and then the national includes not only natural persons but also legal entities. Suppose a foreign company and an Indian company. For example, let me take a foreign company like Texas. There's a company called Texas, for example. Now that's a foreign company, and there is a company called Chitco. Now there's an Indian company. If a foreign company makes an invention and an Indian company makes an invention, both should be treated equally, and there should not be any discrimination between both the companies. The national treatment rule will also be applicable to individuals as well as to the companies or the entities. The next is right to priority. That is, if you make an application before 12 months of the previous application, then your application will be considered. Where many countries register, many countries look for inventions, but then The first applicant for a successful invention will get a priority over other applicants. Once you file it in your national country, you also need to send a copy to the international, that is Patent Cooperation Treaty, PCT. They'll have the entire database, that is who is inventing what. Not only you should tell it to your national country, but also you should go to the international arena. There's a software under which you'll be registering your patent. Next is provisions concerning patent. That is independence of patents. That is anybody who makes an patent or who makes an invention. Like every invention will be treated independently. If I make an invention, that also be treated independently. Whether I'm a member of Paris Convention or not, my invention will be treated independently. So, like, if I make a invention in India, the same invention is made in some other country. That does not stop them from giving patent. They can give patent in their own country. That is, once I've given patent in my country, India, for same thing, nobody can get a patent again. But then, if I've got patent in India for a particular product, and somebody in some other country have invented something differently, they'll get a patent in their country. No law stops them from getting patent. Then, but whoever invents no, his name should be mentioned. That is, the inventor's name should be mentioned. Mr. Abdul has invented particular thing in India. Mr. XYZ has invented something in America. Mr. AB has invented something in China. Now, everybody who has invented something or the other in their own countries will be mentioned, will be named. Then, important importation failure to work and compulsory licensing. Now, whatever inventions you do, whatever the patentee, when the patent is granted and the articles are covered under patent and manufactured in any countries, the union will not stop the patent, because see, when you have invented the patent and you have allowed somebody to reproduce your patent, no law will stop them to making the patent. Once I make my invention, I have all the rights to sell it to somebody, and they can multiply it. No country can stop it. Suppose I'm an Indian. Now I have invented something. Now I have sold it to Chinese. That Chinese man can pay me the money and multiply my invention or multiply the product of my invention. But then, if you don't use it correctly, like if you don't use your invention, you keep it as it is, only then the government will take your patent, take your invention. Now, how will the government come to know you have invented something and you are using not using it? But when you're inventing something, no, you'll give a intimation to the patent office. Then they'll like research. They'll then go for investigation of your patent. Everything will be done. Then they'll find out that a particular product where patent is granted, but he's not using it. or he's not using for a proper purpose. In such a case, they can snatch your invention from you and they can use it for the benefit of the public. Like, for example, I've done a I've invented AK-47. Okay, but I'm not using it. I don't know how to use it. I made it, but I don't have the necessity of using it. Then what happened? They'll take my patent away from me. They use it for themselves. Admit. I'm admitting somebody. Then, where the member state allows such compulsory licensing, including compulsory licensing on behalf of the government. Now, when you're giving compulsory licensing, there are few conditions are to be followed. Now, every compulsory license will be granted case by case. Now, everybody's invention will not be taken by the government. It depends upon case by case where the invention will be taken. Then, uh, that is if a government is trying to take compulsory license, that trying to obtain your invention, it has to give a reasonable, like, give commercial terms and conditions, like a reasonable amount of money, or that is, and when they are taking, whoever is taking, government is taking, they should do it for non-commercial use. Non-commercial means what? They should not sell it for making money. They may take money, but in a very less amount of money. For example, COVID medicines were invented by Poonawalla. Now that medicines were given to people for free. They did not make money out of it. Though the country has taken the invention on the basis of national emergency, but they have not collected money from people. They have not made commercial use of it. Then, a compulsory license must be non-exclusive. That is, it is not exclusive right. Only in case of failure of a patentee, only then they'll take your invention. Then, unless a goodwill is paid to the inventor, they'll not take your invention. Then, a compulsory license, whoever is taking, should be authorized predominantly for the domestic supply, that is within the country. Then, when the object is over now, the compulsory license is liable to be terminated. Then, when I'm taking somebody's invention for compulsory licensing, the patent owner, the person who made the invention, should be paid adequate remuneration, proper amount of money. Suppose if anybody has taken your invention, you can put it for judicial review. That is, you can file a suit in the court of law seeking that somebody has taken my invention without my permission, or what do you say? They have taken my compulsory licensing without my approval, or there was no fault on me. Then this is all. Yeah, let me go to the other site. 1 minute. Block 2. 03. Next is Next is Patent Cooperative Treaty, PCT. Now, PCT. This is a very important document where uh, it was signed in the year 1978, January 24, but it became operational only after 1st June 1978. Now, what is PCT? Basically, Patent Cooperative Treaty is called as PCT. It is an international agreement to maintain cooperation in the field of patent. That is, internationally, they have agreed that they'll do cooperation for patent. Whatever patented inventions are there, uh, it has multi. One sec, somebody is getting in. 1 minute, 1 minute. Okay, okay. No issue. Now, PCT. PCT is nothing but the international office to make your application. That is, you can file a single application, international application, in one language, having effect to the countries. That is, once you file an application, no, it will be applicable all over the world. They can read it in their own language. Even if you file it in your, like, suppose I'm an Indian, I file it in English. Suppose a Spanish wants to read it, he can convert it into Spain and convert it into Spanish language, and he can read it. Then there'll be one patent office. See, uh, you'll be filing an application. Okay, that application will be going to a single office, that is a receiving office. There'll be one office which will receive your application, and that international office will make a formal examination of your application. Then, like, it will make international publication. That is what, like, I told you, like, in India they'll publish, and then anybody has an objection, they can raise an objection. But under PCT, they'll make an international publication. Everybody in the entire world can see the invention, what is to be invented. Then they'll have international search result. What is search result? Like, we have Google, they'll have a software which will search whether such kind of patent is being made anywhere, or such kind of product is being patented anywhere before here. Now they'll have a international database. With that database, they can search whether the invention is patentable. Then once he applies a application at an international level, he can go to the national office. If there's no objection, he can take the patent from the regional office, that is in his own country. But then what happens, it is a very delayed process. Why delayed process means, it's an international application, so they have to make database search, they make data entry. Then once they make data entry, they have to make a server which is accessible to all, which is no, there's no breakdown in that server, everybody can find it. That's why it is very time consuming process. Now, PCT contracting state. So those countries who are parties to patent cooperation treaty anybody from that country can file an application. For example, India is a India is a party to PCT. There is a Chinese in India, but China is not signatory of PCT. But the Chinese who is in India no, can file for the application of patent. Though China is not a party to patent cooperation treaty. Why this is the best benefit of international application. Once you become the party to the patent cooperation treaty, anybody from your country, whether he's a resident of the country or he's a non-national of the country, both can file a application for patent. Then they'll have an international filing date, the date on which you filed the application. Then it will tell from which country the application has been forwarded. Then they'll send a what do you say? They'll send a mail to the regional offices that such kind of application has reached us for patent, and you kindly make a note of it. Then single set of payment. That is, once you make an application, no, only single set of fees you need to pay. One currency. Suppose example, for example, it is $10. Wherever you are, you have to pay $10. Like they'll say you have to pay $10. Now you need not to be worried about it. They pay your country's money, it will convert it into their payment, but there's only single payment. But then if the person's per capita income is less, if he's comparatively poor, then there'll be a reduction. Now, that fees, once you once you are not that much, what do you say? Um, what do you're not wealthy enough. Your per capita income is less. Then you are supposed to pay a less fee compared to others. There'll be transmittal fee to cover the work for receiving office, search fee, then international fee. All these fees will be taken from you. Transmittal fee means one you send a mail, like you'll send your application to the international office. For that you have to pay some fees. There'll be search fees. That is to search whether such an application has been made anywhere and all. There'll be a searching authority. For them you have to pay some fees. Then there'll be international fee to cover the work. These three kinds of fees you need to pay. See, you can file applications in many languages, though it is an international application. So you can file an application in Chinese, you can file an application in English, you can file an application in French, you can file an application in German, you can file an application in Japanese, you can file an application in Russian and Spanish. Other languages are also accepted, so far as Danish, Dutch, Finnish, Norwegian, and Swedish. Like basically, you have to follow Chinese, English, French, German, Japanese, Russian, Spanish. So these languages are accepted. You can file an application only in these languages. Other languages are also accepted. They'll translate it according to their convenience. Then what happened? Once the application is received by the international office, they'll send a copy to international bureau. Now, international who is international bureau? International bureau is a searching authority. They conduct a search, like World Intellectual Property Organization. they have an international bureau. They are the one who will search the who will search whether there's an application. Now, like, you have to send two copies. That is, one, the record copy, that is World Intellectual Property Organization will have a record of it, and they'll send a copy to international bureau who will conduct a search. Then the PCT, that is the international authority, who will receive the fee, and they'll give the fee to search bureau, that is the searching agency. Then there'll be an international search of your application. There are following offices where your international search will be conducted. There is an Australian patent office. Then there is an Austrian patent office. There is a Chinese patent office. There is an European patent office. There is a Japanese patent office. There is a Russian patent office. There is a Spanish patent office, and there is a trademark office. Then Sweden patent office, United States patent office. Now all these offices, the search will be carried on. Minimum documentation, that is whatever is required, you have to give the minimum documentation, like how did you search it, or how did you make such a invention, what is the benefit of your invention, how far it satisfies the uh, criteria of the invention. All these you have to submit the application, and the international bureau will make a search of it. Then once the search report is in your favor, okay, then your application will be processed. If your if the search result is not in favor of you, you will be called to the office, and you can amend the claim. That is, you can amend your research. Now who are those who come now who are that people who are searching your document? Is those are highly qualified people, and who have required knowledge regarding to what is to be patented and what is not to be patented. Then there'll be international publication. International publication will serve you for two purposes: to disclose to the public what is the invention, this to set out the scope of protection which may ultimately be obtained. That is, by international publication, you make the general public, the entire world, what is the uh, what is the invention, and second is what are you trying to invent, and you will be protected to that. Now international bureau now will publish a pamphlet, that is international patent classification, symbol assigned by international search authority. It will have abstract, it will have descriptions, it will have claims, it will have drawings, and international search report. The pamphlet means a small document which will contain everything. Now that will contain what? Uh, like searching the abstract. That is, what is your invention? After abstract, how does it work? What is the description of the? Then, what is the claim? That is, what does the inventor claim? What kind of claimings he has? Then, what is his drawings? That is, how he has drawn his invention. Then there'll be international search report. That is, they'll give the report that we have internationally searched, and nobody has made such an invention, and we are giving it, we are releasing it today. And the pamphlet which they are making it now, it will be published in Chinese, English, French, German, Japanese, Russian, or Spanish. The publication of pamphlet, that is PCT Gazette, the it will be published free of cost to everybody, to all the contracting states. Now they have CD-ROM, that is internationally they'll be sent in their mails. They won't be charging anything. That report, that pamphlet which they are sending, no, it is free of cost to all the contracting states. That is, to all the states who are party to patent cooperation treaty. Then once the report is done, once the report is over, you can ask for preliminary examination. That is, they'll make an examination whether it is a novel, whether the invention is new, or whether there is an inventive step, or whether there is an industrial application to it. Then, for conducting such examination, also you have to pay some fees to them. And then they'll have officers to conduct such examination. Then, national phase. After receiving an international search report where appropriate international preliminary examination report. After search report and examination report, after having a possibility of amending application, you are now in good position to decide whether there is a chance of obtaining patented designated state. That is, if you are from India, you can take your patent from India itself. That's not a problem. Then, if you are paid international patent application fees, you need not to be paying in India. Only the payment of international PCT application is enough. Then, advantage of PCT system. That is, because of PCT, there are many patent offices. There are many examination has done, and there are what do you say? The multiple applications are being sorted out. Then there are what do you say? There is international search report is there. The search cost is reduced, and the manpower is also reduced. That is, there need not to be more people to be appointed. You have online agencies who will search, who will save. Then they don't have cost of publishing. Why they don't have cost of publishing? Because they'll make this pamphlets online. They'll not print it. What they'll do is they'll make it in a PPT form of a thing, and then send it to all the regional offices. And then that does not affect the, like, monetary advantages to the particular state. They can, if the particular country collects the fees, then they can collect the fees and give it to PCT. So that does not economically determine the country. Then, like, since there is an international search is done, the cost of search is reduced. You need not to be searching everywhere and anywhere. The patent office itself will search everything and will give you a report. Then, advantage of applicant. Now, what is the advantage you have because of PCTs? You can file the application in your country. You need not to be going anywhere. Like, you can file the application in your country. They'll send your application to international bureau. And the for like the translation. Suppose you have made it in Hindi, the translation will be done by them. They will not incurring any cost for this. This is all about this. Anybody else has any doubts? Yes, anybody has any doubts?
Sir, it's done, sir?
Yeah, ma'am, it's done.
Okay.
Anybody
So,
has any doubts?